Hello, my name is Andrew Stevenson and I'm the Secretary of the Scottish Law Agents Society. This talk is given on behalf of the Scottish Law Agents Society for our members, and it's intended as a CPD presentation. It's being recorded in September 2025 and it's on conducting a sheriff court proof. Now, this talk is a talk that I've been giving now. It's not exactly the same talk, but it's substantially the same. It's been being given now for about 8 years I've been giving this talk. So that means I've been giving it both before and after COVID, and during COVID as well, of course, when things were completely chaotic and no one knew how things were meant to be done. But it's all settled down quite a bit, and I was in Kilmarnock Sheriff Court just last week to conduct a proof, and for all intents and purposes it was just the same as having conducted a proof back in the year, probably, I don't know, I did a proof in front of Sheriff Crone in that court, I remember, in the same courtroom that I was in last week. That was probably about 25 years ago maybe, and it was just the same process as it was this time round, other than that in this case, the one last week, there were no physical productions lodged before the morning of the proof itself. But I'll come on to that later on, probably, about lodging productions, because that has changed. Probably not for the better, but that's just my opinion. We'll maybe come on to that later on. Anyway, COVID. I mentioned COVID. Now, you'll remember, of course, at one time COVID was all that anyone really talked about, and the courts had to adapt to it, and the way they did that, well, several ways, of course, were attempted or experimented with. But one of the things that they did was they introduced the idea of the hybrid proof, so that some evidence would be heard in person, other evidence would be remote, and that's still something that's done. At the time it came in, the first case that was reported on it was the case of ER versus CD in Perth Sheriff Court in September 2020, so that's 5 years ago. And there was a combination of what was described as social distancing, if you remember that, social distancing, video links. So it was a bit of a novelty at the time. It became for a while quite normal to do that. It's not so normal now. We're more or less back to how we were, as I say, 25 years ago as regards certainly the giving of evidence by witnesses. There is still, I think, a strong desire on the part of those who make the rules to try and maximise remote court appearances, and they've certainly succeeded in the main regarding routine or procedural hearings, which are generally conducted remotely. So the ordinary court, the one I'm most familiar with, is probably the ordinary court in Ayr Sheriff Court, and that's just a whole set of faces on a screen. At the time it came in, it seemed a bit peculiar, but I think we've all got used to it, and I think we've all realised that it's got enormous benefits insofar as you're not having to go to the local court building and hang about for maybe an hour for a case that lasts 5 minutes, which is how it used to be before COVID, of course. So there are certainly good results as a result of the changes that were brought in after COVID. So let me get back to proofs. There was a consultation by the Scottish Civil Justice Council on whether proofs would be taken out of the open courtroom, and whether that was to be done as a matter of course, except if there was a significant issue of credibility. But as was pointed out, certainly by the Society of Solicitor Advocates, of which I'm a member, You never know in a proof whether there's going to be an issue of credibility, really. I mean, there may be instances where that happens, but it's very rare. So the idea that you can somehow divide proofs into those where there's no question of credibility arising and those where there might be, I think that's an impossible task. And we haven't seen proofs being taken out of open court now, so I think that's off the cards now. I don't know, but I'm going to proceed with this talk really on the basis that the way in which proofs are conducted hasn't really changed much in decades. I first conducted a proof in 1992 in a divorce case before Sheriff Jardine in Glasgow, and the only unusual aspect of that case was that the agent on the other side died after the proof was concluded but before submissions, which gave the new solicitor for the opponent a bit of a challenge, but actually he managed to cope with it quite well. So despite COVID, despite the turmoil that caused, despite suggestions that proofs be taken out of open court or dealt with in a different manner, hasn't really happened. So in that respect, what I'm going to say really applies really to proofs that you'll probably conduct, and it applies equally to proofs that have been conducted long in the past. Things really haven't changed that much, and I'm not sure they're going to either in the near future anyway. So the talk I'm going to give is not going to be a kind of textbook narration, because there is a textbook narration already, and you should of course look at that, and I am referring to this book here. This is Sheriff Court Practice by MacPhail. This is the 4th edition by Sheriff Cuby, as he was when this came out. He's now Lord Cuby, of course, but this is still the definitive text on Sheriff Court proofs, and it's also used in the Court of Session as well, actually, because really the procedure in the Court of Session in terms of proofs isn't that different from, in fact I don't think it's different at all really, from how it is in the Sheriff Court. There are a few books on Court of Session procedure. This is my favourite. This is McLaren, and actually this copy used to belong to Hector Byrne Murdoch. He's written his name on it, December 1919, and I've signed it above that with my signature, December 2019, which is probably when I bought this. But this is a great book. It's obviously a wee bit out of date, but the principles in it are pretty much the same as they have always been. The other book that you ought to get your hands on is this. This is quite an old edition. I think this is 10 years old now actually. Green's Annotated Rules of the Court of Session. This is a great book for any court practitioner actually, because it illustrates all kinds of concepts and features of all manner of litigation. So for example, things like cation for expenses, that's in there. Well, that's something you encounter in the Sheriff Court, or assisting of mandatories, that kind of thing. Certification of experts, it's all in there. I mean, that is a really good book. It's actually taken from the Parliament House book, so it is updated quite a bit. But as I say, this is about 10 years old. I really ought to get another copy of this. So those are the basic books. There are other books, of course. I've got quite a few Court of Session ones. Middleton, I think, is one of them. Is that right? What's the name of them? I can't remember the name of these books, but there are a few. And of course, with Sheriff Court Procedure, you've got Dobie on Sheriff Court Procedure, but that's a bit old now. I think that's from the 1950s, so that's getting on to be quite old. But I would recommend MacPhail, McLaren, and Annotated Rules of the Court of Session. The other book that you should have access to is Walker and Walker on the Law of Evidence. The last edition, I think, is the fifth edition from 2020, unless that's been updated again. I'll come on later to evidence, but don't fall into the trap of thinking that there aren't any rules of evidence in the civil courts anymore. If you do any criminal work, you'll know that there are quite stringent rules about evidence in the criminal courts. The rules in the civil courts, of course, are far more relaxed, but there are still rules, so you need to be aware of those. And talking of rules, there are also the Law Society of Scotland practice rules from 2011, I think, unless they've been updated as well, but I don't think they have. And practice rules are, of course, something that you need to be aware of, and I'll come on to them later on, but they are important because, well, I'll come on to this as well, but complaints, you don't want to have a complaint arising out of anything, but certainly arising out of a litigation or a proof. If you adhere to the Law Society practice rules, that is a fairly good indication that you've followed good practice, best practice, and you've followed the rules of your professional body, and that will protect you, or it should protect you quite well if there's a complaint down the line. If you deviate from the rules, you're potentially going to be in trouble, so try not to deviate from the rules. Right, textbooks are very useful at illustrating principles, but the problem is, each proof is something that turns on its own facts and circumstances and merits, and until you're actually experienced in doing proofs, the books themselves are only going to take you so far. So you need to get some experience in doing proofs. So I'm not going to read out textbook explanations. They are there already. I've indicated where they're to be found. I'm just going to try to give you some assistance or guidance or whatever based on my own experience of having conducted proofs. And I've done hundreds of proofs. I've done proofs in all manner of subject matter as well: family law, reparation, boundary disputes, interdicts, just about anything really. And I've conducted proofs in the Court of Session as well. And as I say, I've been doing it for over 30 years, and I'm not at all saying that I'm great at doing proofs. I'm definitely not saying that. I've probably lost more proofs than I've won. I've been given some real hospital passes, and I know what can go wrong. I haven't had too many complaints, but I think that's probably just luck. These things could just be around the corner, you just don't know. One of my favourite quotes about proofs, well, it's about litigation actually, it's from a case called Susan McNeish versus Advocate General from 2004. Litigation is a risky business. For one reason or another, it rarely goes according to plan. That's Temporary Judge Reed, QC, 2004 QC. And I love that quote. I just think it's so true. It's absolutely true. Litigation is very risky, and it does rarely go according to plan, or at least in my experience it does. Maybe that's saying something about the way I conduct litigation, but I've seen it happen many times that the best laid plans, and all that. So do bear in mind that litigation and proofs are extremely risky, and risk management is an absolutely essential part of dealing with this kind of work. The suggestions and the advice that I'll be giving are, in a sense, a bit of a counsel of perfection, because you won't always be able to conduct a proof having been able to carry out as much preparation as you would have wished. And if you're doing proofs for other firms, and I've done many for other firms, You will sometimes get handed the papers, sometimes the day before, sometimes the same day. I've had that happen to me the same day. And in that sense, you are rather hampered in terms of the amount of preparation that you can undertake. I once did a proof where I was handed the papers at lunchtime, and I conducted the proof at 2 o'clock, and I looked at the papers and the taxi going down to the court. I was in front of Sheriff James Murphy, so that was a while ago. That was a road traffic case. And he was an absolute gentleman, as he always was. So, going back to what I was saying about complaints, I would just emphasise at the moment that litigation in general is risky, and also statistically you will have as many winners as losers, usually. Well, on the whole, because you may have more than one pursuer and more than one defender, of course. But the point is that in the outcome of virtually every litigation, somebody is going to be disappointed with the outcome. Sometimes both parties will be disappointed. That's not uncommon, but certainly there will be some disappointment on the part of somebody, and it's becoming more and more of an issue that disappointed clients want to find a scapegoat. They want to find somebody to blame. Now, if you act for a client who loses in a litigation, the best scapegoat, if you like, is probably the sheriff. So what you want from a complaints avoidance perspective is you want the client to blame the sheriff for not believing him or her. That's the ideal outcome. So you're in the clear, and it's the court's fault for not finding in favour of the client. Unfortunately, however, things don't usually go as smoothly as that, and I have noticed quite often that sheriffs will frame a judgment in such a way that they'll say that your client failed to do something. So for example, they'll say the client, whoever it is, it's pursuer or defender, whoever the loser is, if you're acting for that person, the judgment will say that the litigant failed to produce sufficient evidence to vouch some aspect of the case, or they didn't bring a witness or something of that nature. In other words, they'll blame the client. And of course, if the court is blaming the litigant for not having taken a step, that litigant, your client, will then blame you for not having produced the document, cited the witness, or whatever the shortcoming is that's identified by the court. So it's all a bit of a blame game, and it's something that you need to really be careful about. I've always thought, I kind of wised up to this really early in my career. I always thought the single most important consideration is to protect yourself personally against the risks that are unavoidable and which are inherent in running any proof. With regards to that dictum that I mentioned there about litigation as a risky business, you have to be really aware, mindful that clients are all too ready to go off to the SLCC to complain that it's your fault that they lost their case. It's just a common problem these days, unfortunately. So you have to keep self-preservation as your priority, and in fact, in doing that, you're also probably going to be serving your client's interests as well. So there's no conflict as such, really, between self-protection and looking after your client. Turning up in court and running the proof is quite often the easiest part of any litigation, and it can be the most enjoyable part as well. Not always, but quite often it is. The difficult part, the tedious bit, if you like, is the preparation. However, that is probably the part that most assists in your efforts to minimising risks to yourself. So, risk management, this is something that I've talked about before, and I don't apologise for making a thing about it again, because I do think it's the most important aspect of the job these days, and that applies not just in litigation but in any form of court work, civil court work, criminal court work, tribunals, whatever it is, but also generally executories and conveyancing and all these other areas of work. Risk management. So if you're thinking about risk management in the context of court work, civil court work, the best way really is just to be blunt about it and say, who is going to complain about you and what are they going to complain about? So think about the capacity in which you are acting. You're always acting in a number of capacities, and I've identified a few. Maybe I've missed one or two, I don't know, but we'll go through the list anyway. So the first one is that you may be a direct agent for one of the litigants. You may be acting directly for pursuer or the defender. Probably not both, one or the other. You may be acting for a couple of defenders, which is okay as long as there's no conflict of interest between them, of course. But anyway, acting for a litigant puts you in a fiduciary position as agent, which means that you have to put the client's interests first. Okay, quite a general statement that. It could apply in so many different ways, but that's the general principle. Fiduciary duty, put your client's interests first. Secondly, you might be conducting the proof on behalf of somebody else, another firm of solicitors, something I've done many times, and that requires that you look out for the client, their client I suppose it would be, but also for the instructing agent as well. So you need to look out for both the agent and the client. Thirdly, you are always an officer of the court, and that's commonly interpreted as meaning that you're not allowed knowingly or carelessly or recklessly to mislead the sheriff, because you're an officer of the court. Fourthly, you are either going to be an employee or you're going to be self-employed, so you have to make sure that you get paid for what you're doing and that you do the work profitably, unless it's a loss leader, of course, but generally speaking you don't want to be doing all this and not getting a good or a reasonable fee from it. There's no point at all in conducting a proof and undertaking all that work and taking all those risks on if you're going to lose money, really. Fifthly, you might be the recipient of funding from a third party, for example the Scottish Legal Aid Board or an insurance company, and that means you have to have regard to the costs to and restrictions imposed by the third party funder. Sometimes you'll get a situation where the money's put up by a relative as well, and that can cause certain tensions. There are some who think that he who pays the piper calls the tune. You don't really want to be in the debt of someone who isn't actually a party, who's maybe a parent or a friend of the litigant. That can cause certain complications. But anyway, so third party funders, you've got to be careful about that. And the last one I put down here is that you are the colleague of the solicitor, if there is a solicitor, for the client's opponent, and that means you have to have regard to your duties towards your fellow agents, and that one can give rise to certain problems and certain issues, but we'll come on to that later on. So each of these capacities has its own interests, and these of course can conflict. So going back to the question of needing to protect yourself against risk, you can see that these capacities suggest and indicate where the conflicts or where the risks lie and where the conflicts are likely to be and who's likely to complain as well, of course. So let's go back to the first one, which is where you're acting directly for a litigant. Clients will generally complain about three things. First one is the delay, second one is cost, and third one is a bad result. And it's always been like that. For as long as I can remember, it's been like that. There is nothing new about clients complaining. What is new is that we have the SLCC, we've got a compensation culture, in my opinion. We've got an erosion of respect for professional people. And in my opinion, having looked back over the decades, I think there is an increasing tendency on the part of clients not to take responsibility for their own lack of credibility. People just seem to be they just refuse to accept that they've been caught out, that the sheriff hasn't believed them, that the sheriff said they're a liar. People just don't want to accept that. Whereas before, 30 years ago, there was more of an acceptance of, okay, fair enough, lost the case, I wasn't believed, and they didn't put up an argument about it. So there are all these risks, and I don't think it's any better in terms of how it was before. I think it's got worse. What I would say is that from a self-protection perspective, if for no other reason, it's always better to try and settle a case. It's always less risky to settle than to go to proof. And the reason is quite simple. If you're dealing with a payment action for, let's say, £20,000, if you're pursuing that action and you settle for £15,000, then your client gets £15,000 and they'll be happy with that because they're instructing you to settle for 15, so they'll be happy with it. Generally, they might think about it later on and think, oh, I could have got more than that. But generally speaking, they'll be happy with what you settle for. And in that respect, the client gets £15,000 in their hand. Whereas if the case had gone to proof, the client might have got more than 15, but might have got less, or might have got nothing. But the point is that if you settle the case, no one will ever know what would have happened had it gone to proof. And that protects you in a lot of ways. I mean, it protects you in the sense of, well, the outcome has generally been satisfactory to everybody. So you've avoided the risk of the case going pear-shaped or just not having gone the way that you wanted it to go. And that applies both for pursuers and defenders. No one knows what would have happened to a proof that doesn't actually go ahead. You don't know who would have won, you don't know how much would have been awarded, you don't know what the position would have been about expenses and so on. So in a sense, settling the action is the best outcome. And the risks that I've mentioned, these can be used to persuade the client to settle, because you can say to the client, well, look, I can only do so much. This is only under my control to a limited extent. I don't know how you'll come out in court as a witness. Don't know what the other witnesses will come out like. I don't know what the sheriff will do. All I can do is present the case as best I can, but I don't have ultimate control over the outcome. And I'm not saying you should worry the client, but you definitely have to be aware of the risks. And most people want to avoid risks. So in a sense, it actually makes a lot of common sense to settle actions. Right. Try and settle cases is what I'm saying. The other thing you can try and do, of course, is lodge a tender or a pursuer's offer. That's a good way of trying to settle an action, and also a good way, of course, of putting pressure on the opponent. Let's say, however, you can't settle the case and it has to go ahead. Well, you're acting directly for the litigant, and there will be tensions and conflicts, for example, as to how you minimise the risks of complaint and how best to promote the client's interests, taking into account factors such as cost and delay. I've always said it's a bit of a balancing exercise. There will always be more evidence out there than you lead, and that's the case wherever you draw the line. I had a proof in 2018 in Glasgow where the client wanted to call 14 witnesses, including a company director who was based in North America somewhere. Absolute overkill. We didn't need 14 witnesses. We didn't even need 4. We ran the proof with 3 witnesses, all of whom were in the United Kingdom. But the client wanted to call 14. Now, the danger you have there is if you, and it happened to me once, I'll probably come on to this later on, but if you don't call everybody that the client wants you to call and your client loses, there's a danger they'll turn around and say, well, if you'd called so and so, it might have gone the other way. It probably would have gone the other way, even if that's complete nonsense. You know, it gives you a problem in that the client could complain if you don't call absolutely everybody. So you have to try and rein them in a bit, persuade them that you don't need 14 witnesses. And most people, if they're reasonable, will understand that. I had a case where that very situation happened to me. The client wanted to call witnesses from abroad, persuaded him not to do that for reasons of cost. He lost, and he then went to the SLCC about me, and he said, you know, if we'd called that witness that I wanted to call, it would have made a world of difference. It would have completely altered the outcome of the action, which is utter nonsense, complete baloney. But it tied me up in so many hours of stress and effort trying to deal with that. At the end of the day, the complaint was bombed out, as I knew it would be, but you know, there's always this niggling worry at the back of your head, you know, what happens if it gets upheld or so on. So you don't need all that nonsense. But the thing is, you know, I don't know what I could have done differently in that one. It's just risks that you get with clients. Some people are just never happy with the outcome. He lost on credibility, by the way. I didn't believe him either, but there you go. So these are the issues. Trying to balance the interests of the client in terms of trying to cut down the costs, but at the same time trying to protect yourself against a claim. So other points I would make when you're acting directly for a litigant: remember that you can only act on your client's instructions. So for example, if that guy had told me to cite the witness, I would have had to do that, obviously, regardless of whether I thought it was necessary or appropriate. So you got a duty to advise, but you've also got an obligation to follow instructions, because clients do not require to follow your advice. It's not a quid pro quo. You have to follow the instructions. They do not have to follow your advice. Of course, if there's a real issue there, you may have to withdraw from acting. I mean, for one thing, if the client isn't following your advice about something important, you have to say to yourself, he doesn't have any faith in my abilities here. It would be better if he just got another lawyer, right? So that's something you need to have in mind as well. The other point I'd make about acting directly for a litigant is that the instructions that you have from that client can be withdrawn for any reason, for no reason, at any time. If we withdraw from acting as solicitors, we've got to make sure that we don't do it, or try our best to make sure that we don't do it at a point in time where the client is prejudiced. Sometimes you have to crack on and just deal with something where in other circumstances you would withdraw, because it would prejudice the client if you withdrew. I mean, withdrawing on the morning of a proof, that is going to prejudice the client, obviously, because it's going to cause havoc in terms of the thing will have to go off, and that will involve cost and so on. So you may, and if it's happened to me, you may get a situation where the client gives you instructions or does things where you would have withdrawn if it had happened 2 months before the proof, but where it happens on the day or the day before, you just have to sort of navigate your way through it and crack on. But if instructions are withdrawn, that of course gives you a bit of a problem, or it might do, in terms of getting paid. And this is why it's really important that you get funding up front. Getting funding up front is always a problem in litigation. I'm not the best at it, I have to say. I've had to sue a few clients. Got a decree in a case where I was suing a client just last week. So I'm not the best at it. I think one of the problems is costs can escalate rapidly. And what happens is you're focused on the proof or the case. You take your eye off the ball in terms of getting funding. And before you know it, you're at the point where you're at the end of the action and you're owed thousands of pounds in fees and you haven't got the money. So make sure you get funding up front. Make sure you keep on your clients back in terms of getting the money early as possible in the case. Get the money from the client when the client needs you. If the case is finished, the client doesn't need you anymore, why are they going to pay? Particularly if they've lost and they're feeling aggrieved about that. The last thing they want to do is pay their lawyer. So make sure that you do get funding up front. The other point I would make, and this is something that not everyone can act on, but the point is you can always decline to act for somebody. This is one of the few advantages that solicitors in private practice have over, for example, teachers, doctors, those in the public sector. We get the choice over whether we act or not. And if you feel uncomfortable, like somebody's trying to lead you into doing something unethical, you can decline to act, or you can withdraw from acting, and in fact that may well be the only thing that you can do. Do it, as I say, do it as soon as you can. Don't leave it till the last minute, because that risks causing prejudice to the client. As I say, sometimes, I know people who've worked in firms where they've really been compelled to keep acting for somebody because the client is a good client of the firm, gives them a lot of business, and the employee, usually it's a junior employee, feels the need or is compelled to carry on acting when they don't really want to. So I get that you can't always withdraw from acting for a client because you feel uncomfortable, but make your concerns known to your employer or your senior solicitor in the firm if you do want to withdraw, and explain why, and try and persuade the person in the firm to agree that you should go your separate ways from the client. But anyway, that's a set of points that I would make about the situation where you're acting directly for the litigant. If you're acting, this is the second one, if you're acting as an agent for another solicitor, that can give rise to certain conflicts. I know all about this because I've acted for other solicitors numerous times. Probably, I would say about a third of the proofs that I've done have been for other solicitors. I think all the road traffic cases that I did, I haven't done one for a while, but I was doing a lot at one time. They were all for another firm of solicitors. But that situation where you're acting for another firm, that can give rise to certain problems, some of which I've encountered. So say for example, say a proof isn't going well because the pleadings aren't great. You're having to work with pleadings that somebody else has drafted. Or say the instructing agent hasn't cited a witness or lodged a production, or their precognitions are defective. You're there in the heat of the moment in the court, in the thick of the battle in the courtroom, and you find you've got a problem and it's not your fault. So what do you do about it? Well, there's no simple answer for that, because it depends on the circumstances, but you might want to get the proof halted so that consideration can be given to amending, or trying to get hold of someone to give evidence, or lodging a production. There could be all manner of things that need to be done, and which become apparent only after the proof is started. However, if you do try and get a halt put on the proof so that you can deal with this issue, that can give rise to problems. So, for example, there could be an adverse consequence in expenses if that happens. Plus, of course, you're drawing attention to the omission by the instructing solicitor, and the instructing solicitor won't want you to do that. They won't want attention drawn to something that they've messed up. It has happened to me, and the way I've dealt with it is I have asked for a short adjournment. I've told the sheriff that I require time to take instructions about a matter that has just arisen, and that I've sometimes said I need to discuss it with the instructing agent, the principal agent. I haven't said anything beyond that. And then what I've done is I've gone and I've phoned the principal agent, I've explained the problem, and I've said, what do you want me to do about this? And that way they're taking the decision, and they're taking the responsibility for what happens next. That, by the way, is why you should always ensure that you can make direct contact with the instructing agent. Always get a phone number from somebody who is going to be available at all times during the course of the proof, so that you've got that line of communication, you've got that open to you, that you can go and phone the person and speak to someone and let them take the decision and the responsibility, because ultimately it's their case, or it's their client's case, but it's more their case than your case. So they're kind of higher up the chain, as it were. There are some advantages in acting for another solicitor, one of which is that there shouldn't be any problem getting paid. Section 30 of the Solicitor Scotland Act 1980 states that a solicitor who employs another solicitor to do work, like conducting a proof, is liable for the instructed agent's fees and outlays, unless the instructing agent expressly disclaims any such liability, which is highly unlikely to happen. So this is a statutory exception, of course, to the rule that we all know about, whereby agent for a disclosed principal has no personal liability. In the situation here I'm discussing, the Act overrides that, and the principal agent does have liability. So if you're running a proof for somebody else, you shouldn't have any responsibility for funding generally. It's not your job, for example, to pay the shorthand writer or the witnesses. There is the disadvantage that you may never have met the client until the morning of the proof itself. It's happened to me plenty of times. Sometimes it can be advantageous to meet the client beforehand. If you can't do that, maybe give the client a phone. If you can't do that, just make sure that the client knows that you're going to be conducting the proof. There's nothing worse than turning up at court to be met with someone who says, "Where's Mr. whoever, the principal agent, who are you, and what are you doing here?" That's not a good start. And it doesn't need to be like that. All that needs to happen is a principal agent tells the client that you'll be appearing and that you're a great lawyer, so that they know they're in safe hands. Right, officer of the court. This is one that you have to be aware of. Solicitors are officers of the court. By the way, party litigants are not officers of the court, which puts them at an advantage in some ways, because they're not obliged to, for example, draw the court's attention to case law that is unhelpful to their own case, whereas we are, because we're officers of the court. So we're under certain obligations that don't affect party litigants. I've always said, if you're ever reminded that you're an officer of the court, that is not a good sign. That's bad. Just as if a witness is reminded that he's on oath. That's not a good sign either. Anyway, the classic thing is, if you're an officer of the court, you are not allowed knowingly or recklessly or carelessly to mislead the court. So carelessly would be, if you're asked a question by the sheriff and you don't know the answer and you just take a guess at it and guess wrongly. So never do that. I have done that to my cost early in my career. I soon learned not to do that. Knowingly, in the context of a proof, that would be in allowing evidence that you know is false to be led. Quite often you don't know whether the evidence is false or not, in the sense that you don't know whether what you're getting told by the client or the witness in your office is true or not. Right? I mean, everybody accepts that and knows that. But if the witness produces a document that bears to be dated 6 months before, but he tells you, he's printed it off that morning, and you lodge that document and don't make it clear that it was printed off that morning, that's obviously knowingly and kind of fraudulently, really, quite improperly misleading the court. So you're not allowed to do that, believe it or not. Usually it's never normally as clear cut as that. It's more likely to be, for example, in a divorce case, your client tells you that he's got an asset or an income stream he doesn't want his wife to know about, doesn't want the court to know about it. That can give you a bit of a problem. Do you insist that it be disclosed? There is obviously a duty of disclosure in divorce cases. In other cases, there isn't such a duty of disclosure, so you have to, as I say, I can't make hard and fast rules about this or hard and fast statements about it. It just depends on the circumstances, but you do have to be aware of your duties as an officer of the court, not to be a party to misleading the court. You just can't do that. I'll mention something that happened to me. I once did an employment tribunal where a witness of my client denied having paid cash to an employee. The case was all about tax evasion, but not in relation to one of the employees. It was in relation to somebody else. But this witness claimed that he hadn't paid cash to the employee, not the main employee, the other employee, the individual with which the case was not really concerned. So what I'm trying to say is, it wasn't really a material factor insofar as the outcome of that action was concerned. It was peripheral. It wasn't that important. It wasn't important at all, actually. But the witness who had told the tribunal about this, he phoned my office later that afternoon and admitted that he had lied. And he apologised, and he said that he'd been taken by surprise. He wasn't expecting to get asked about this, which I wasn't either, actually. He was under pressure, and he just blurted out this answer that was untrue. But looking back on it, he needed to get it off his chest, and he told me about it. So his conscience obviously troubled him quite a bit, to the point where he phoned me up to confess, as it were, that he'd lied under oath. And he never would have been found out. I would never have come to light if he hadn't told me. Because, as I say, it wasn't about anything important. However, because he gave me that information, I obviously had to do something with it. So I had to contact the tribunal chairman, which I did pretty well immediately, and just explained the position to the tribunal chairman. And in fact, not a great deal came of it, other than that the client's evidence was pretty much disregarded in its entirety, because his credibility was obviously out the window. But he wasn't reported to the fiscal for perjury or anything like that. Nothing adverse happened to him. But that's the only time I think anyone's ever confessed to me that they've lied in court. And I've been doing this for 35 years now, and that's the only time that's ever happened. I said earlier, I think, that you cannot knowingly allow false evidence to be put before a court. Now, that does not mean that you have to believe everything that your client tells you. We all come across agents. I came across an agent just recently who falls into this category. These solicitors who believe everything their client tells them. Don't you find that annoying? You feel like saying, listen, all our clients can't be telling the truth all the time, right? So what makes you think your client is telling the truth? Anyway, I don't say that, but I think that. The point is, you cannot believe what your client tells you, and you don't need to believe it either. Whether you believe it or not is entirely irrelevant. What you have to do is ask yourself, is the sheriff going to believe this? Not whether you believe it or not. So, if you're told something, you may think it's a pack of lies, but as long as the client hasn't told you that it's a pack of lies, you're quite entitled to present that to the court. You may be involved in a case where you're arguing in favour of an outcome that you think personally would be an absolute disaster. For example, awarding contact to a convicted child abuser. You may find yourself in a situation where you're having to argue that it's in the best interest of a child that someone who you think is entirely unsuitable gets contact to that child. But you have to do that, and if you can't do it, then don't act. Just don't act in the case. I sometimes get asked to present a case that I think's utterly hopeless, or a case I don't think will stand up to scrutiny, or I don't think there's enough evidence to it to substantiate it. And the way I deal with that is I never say to the client, look, that's a load of nonsense, I don't believe you. What you say is that I'm concerned that the court will not believe you, and then you say why. Because remember, your opinion, your assessment, your analysis of the evidence, particularly regarding credibility, does not matter at all. What matters is what the sheriff thinks. So therefore, what you have to do is judge whether you think the sheriff is likely to believe your client, and whether the sheriff is likely to accept the sufficiency and weight of the evidence that you're proposing to lead. Now, being an officer of the court does not mean that you have to avoid standing up to sheriffs. And I've mentioned before, there are talks and seminars with titles like How Not to Annoy Your Sheriff. In my opinion, there is nothing wrong with annoying a sheriff. It depends entirely on why the sheriff is getting annoyed. I'm not, by the way, advising you to annoy a sheriff. What I'm saying is that not annoying a sheriff should not be your principal motivation. So, the sheriff may be getting annoyed because you're asking stupid questions, or let's say you're bullying a witness. The sheriff in that situation is quite right to get annoyed, because you shouldn't be doing those things. On the other hand, you may find yourself in a situation where you're trying to conduct a proof, you want to call a witness, you think the sheriff's already made his mind up, and he's getting annoyed and he's getting impatient because you carry on regardless. Now, that is not a good reason for a sheriff to get annoyed. The sheriff should be letting you do your job. If you think it's reasonable to call a witness, then you should call a witness. And don't be deterred from doing that just because the sheriff's getting annoyed. There used to be a sheriff in Glasgow who didn't really, in my opinion, really understand the concept of, or the necessity of corroboration. So you'd lead the witness, your client usually, and then you would lead another witness to corroborate the client, and the sheriff would say, well, I don't need to hear corroboration, I've heard your client. And you would try and make the point, well, corroboration is usually a good thing, and he'd say, well, it's not necessary to have corroboration, which is absolutely true. Of course, you don't need corroboration, but you're better having it than not having it. And bear in mind that you may have to appeal a decision, and you're in a far stronger position before an appeal court if you've got corroborating evidence. So don't let yourself be deterred from carrying on in the way that you want to conduct the proof just because the sheriff's getting annoyed, unless, as I say, there's a good reason for the sheriff getting annoyed. But if you don't think there's a good reason, then be fearless. There are rules about this, and practice rule B113, this is in the Law Society practice rules, it's headed up relations with the courts, and says, amongst a few other things, that you must maintain due respect and courtesy towards the court while honourably pursuing the interests of your client. So that kind of recognises there's a bit of a conflict there. So you've got to be respectful towards the court, but also you have to be mindful of your obligations to advance your client's case. Because bear in mind, you're only there because you're instructed by the client. So you have to advance the client's interests. There's also a rule that applies to solicitor advocates. So it's under a different kind of heading. It's C4-419. And that says, and I'm quoting, you must be fearless in defending your client's interests regardless of the consequences to yourself, including, if necessary, incurring the displeasure of the bench. Now, I don't know why that's under the heading for solicitor advocates, but not solicitors, because I think it applies to solicitors just as much as it does to solicitor advocates, that you should be fearless in defending your client's interests, and if the court gets angry, then too bad. So I think that does apply to solicitors generally. So anyway, I'm not going to say anything more about being an officer of the court. I'm going to move on to the fact that you are an employee, or if you're self-employed, you have to make sure that you are properly funded. And as I mentioned before, this is something that people probably don't pay as much attention to as they should. What you've got to make sure about is that you don't end up landing your employer or yourself with a bill which your employer or you aren't able to pay without resorting to using your own money. In other words, you've got to get proper funding up front. Going into court is incredibly expensive, and I'll probably come on to that later on, but it's an incredibly expensive thing to do, and you have to make sure that it's not personally expensive. I like to say that you should never find yourself as piggy in the middle. In other words, don't be left in a situation where you're having to fork out money when you don't have the funds to cover that outlay. Please bear in mind, a lot of the costs involved in running a proof are deemed to be the personal responsibility of the solicitor. The reasons for that, I suspect, are to do with public policy. You don't want a situation where witnesses are having to turn up at court and then they can't get paid because they're having to pursue your client, and your client doesn't pay them. That's not good for the wheels of justice. It doesn't oil the wheels of justice if you've got problems like that. This system of ours, it depends on witnesses knowing that they're going to get paid by somebody if they turn up. It brings the whole system into disrepute if they don't get paid. And the easy way to get around that is just make the solicitor personally liable, which is exactly what the rules say. So if you cite a witness, you're personally liable. The client is obviously liable as well, but witnesses are probably more likely to go after you than they are to go after the client, because they know you've got insurance, and all solicitors are all wealthy anyway. I mean, public knows that all solicitors are really rich, plenty of money, so they're the ones that will tend to be targeted by witnesses who are looking to recover their costs. Now, the situations in which you're personally liable, right? Shorthand writers, witnesses who you cite, and the last one is sheriff officers. There's also court fees as well. I'll come on to that later on, because it's not such a, I was going to say it's a grey area. It's not as clear as the other situations that I've mentioned, but I'll come on to that later. But let's say shorthand writers. Now, technically, the court can dispense with a shorthand writer as long as the parties agree. So that's in McPhail, Ordinary Cordial 29.18.1. McPhail chapter 16 paragraph 32. 16.32. That's chapter 16 paragraph 32, I think. I don't think, generally speaking, though, that you do want to dispense with a shorthand writer. It's something that I would resist, because if you don't have a shorthand writer, it means that you're hampered at appeal, because there's no record of the evidence other than the sheriff's own notes. So dispensing with a shorthand writer, I don't recommend doing that. You may not have any personal liability in relation to witnesses, because you might not have cited any witnesses. So the witness might have attended voluntarily, or your client might be the only witness, and you wouldn't cite your own client, of course. Or you might not have any witnesses. I've certainly conducted proofs where I haven't had any witnesses. I conducted a proof in Edinburgh where I was simply cross-examining the opponent's witnesses, and I didn't lead any evidence at all. It was a road traffic case involving a private hire driver who was claiming astronomical costs because he said his vehicle had been off the road for a week or whatever it was, and what we were arguing about there was the veracity of his accounts. So obviously I didn't have any witnesses, but I did cross-examine him and his accountant, and it went quite well, actually. So you may not have any witnesses, but normally you would have. If you cite them, you are personally liable. Right, sheriff officers, you may not have instructed sheriff officers to cite witnesses. You wouldn't generally, in fact, in my experience, I wouldn't normally instruct sheriff officers to cite witnesses, because, for one thing, if you're having to do that, you have to ask why. If the witnesses are people that aren't going to attend unless they get sheriff officers at the door, are they really going to be helpful to your case? Are they really going to be cooperative? So, as I say, I don't generally use sheriff officers to to cite witnesses, because it's usually unnecessary to do that. On the subject of being personally liable, remember that advocates are never personally liable for any of these outlays that I've mentioned. And if you do instruct counsel to conduct a case for you, you just remember that they may recommend that you cite all manner of witnesses. They're not going to be looking to pay those witnesses' expenses. You are. So, you might want to factor that into the discussions that you have with counsel, and have regard to it and who you cite. Even in the court of session, the solicitor is personally liable, it's not counsel, and there's a specific rule of court in the court of session, 36.2.4, according to my notes, which deals with that. Right, shorthand writers, I've sort of mentioned them already. Likelihood is you will have a shorthand writer there. You don't have shorthand writers in Edinburgh Sheriff Court. I did a proof earlier in the year in Glasgow where we didn't have a shorthand writer because the courtroom had recording facilities, and that actually went really well. It was actually a summary trial court, and the proof took place in there, and the evidence was recorded and extended later on, but no shorthand writer there for that one. Court of session, of course, you don't have shorthand writers. If you do have a shorthand writer, the fees are payable in the first instance by both parties, but the solicitors for the parties shall be personally liable for the fees. So as a solicitor, you're having to personally guarantee that the shorthand writer will get paid. This is another statutory exception to the rule that agent for a disclosed principal isn't personally liable for the debts of the principal. I've mentioned one already, section 30 of the 1980 Act. In relation, of course, to the defender's agent, it's even more radical an exception, because the defender, unless the defender is counterclaiming and that's the only thing in issue, where perhaps the defender is instructing the shorthand writer, the defender generally does not have a contract with the shorthand writer. The rules say that the obligation lies primarily with the pursuer. So technically, even if you are having a proof on a counterclaim only, it's still the pursuer who has the obligation to instruct the shorthand writer. The case I had last week where there was a shorthand writer there, that case was proceeding solely in relation to a counterclaim, and my client was a pursuer. So the obligation actually was on me to instruct the shorthand writer, but the defender's agent agreed to instruct the shorthand writer. So fine, that was alright. Now the fees of shorthand writers, fees of witnesses, they're both dealt with in the same Act as sederant. When I used to give this talk before, I tended to refer not just to the 2019 Act of Sederant, but also the 1992 Act of Sederant, which referred to pre-2019 proceedings. But we've moved on a lot. I don't think there are any pre-2019 proceedings still ongoing in the court, unless they've been insisted for years. But generally speaking, we're now dealing only with the 2019 regulations. the outlays actually for shorthand writers and witnesses are pretty much the same as they were under the pre 2019 rules, but they're all there. Witnesses, chapter 17, schedule 6. Shorthand writers, it's chapter 7.2 and schedule 7. So have a look at that, and then you'll see what the potential costs could be. Which you need to be aware of that, because bear in mind you're going to be personally liable to pay it. So have a look at chapter 7.1, schedule 6, 7.2, schedule 7 for witnesses and shorthand writers. I'm not going to spend a lot of time telling you what those regulations say, because you can read, so go and read them. But generally speaking, for shorthand writers, there's an attendance fee, there's a cancellation fee, there's subsistence allowance, copying charges. The most significant potential cost, however, is in relation to the extension of the shorthand notes. And extension of the shorthand notes, of course, just means that they're typed out. That is an extremely expensive process. It's the most expensive element of the whole process of instructing a shorthand writer. So you're always hoping that the court will not insist on the extension of the shorthand notes, although you don't have any control over that. So you have to instruct the shorthand writer. You have to be personally liable for the costs of the shorthand writer, but you don't decide whether the shorthand notes get extended or not. That's the cost. That is a choice of the sheriff. You do, of course, have to ensure that you are not going to be left out of pocket if the court does extend the shorthand notes. So what I'm really saying is, assume that the shorthand notes are going to be extended. Make sure you have got plenty of money up front to cover that cost. I checked with a well-known firm of shorthand writers, and they told me that an hour's oral evidence equates to 40 sheets. Now, that's £290 an hour. So, yeah, a 5-hour proof could generate a fee of about £1,400. And of course, if the shorthand writer's VAT registered, not all of them are, by the way, but if they are, that cost will be inflated even further. So I tend to get at least £1,000 from the client. I would be getting at least £1,000 per day for a proof, just to cover the risk of a shorthand writer being required to extend the shorthand notes. So just be careful about that. It's not so common these days for shorthand notes to be extended, but I had a case earlier this year where the shorthand notes were extended, and luckily I had plenty of money up front from the client, so that wasn't a problem. Right. Witnesses. There was a time where the COVID rules made quite a big difference to this, because at one time, under the emergency legislation, there were quite stringent restrictions on being out and about, social distancing, standing, what was it again? Was it 2 meters away from everybody? All that stuff that we had to deal with. Physical attendance dispensed with, and they didn't want people going into court buildings, so there were all these rules about remote attendance of witnesses. But as I say, that's all pretty well gone now. But when those rules were in force, one of the happy consequences, I suppose, would be that you weren't really having to pay so much in terms of witness costs. So, for example, witnesses would not have travel costs. they wouldn't have hanging around costs, which is really important for expert witnesses, of course, because waiting time is expensive for witnesses who are professional people or just expert witnesses. So travelling and subsistence costs didn't need to, and to some extent waiting costs weren't a problem under the COVID regulations. But as I say, we're kind of past that now, and things are pretty much as they were before. So again, the risk has got worse for solicitors. So the key really to managing witness costs is communication with your client and also the witness. Be very careful that you don't have a situation where, and it's happened to me, where you instruct someone, a professional person, who then goes off and refreshes their memory by looking at notes or looking at this or that, and then they send you the bill for their time in doing that. You need to make clear to witnesses at the outset that you don't want them to incur any costs unless you give them the okay to do it and it's controlled. So you need estimates of what people are going to be looking for, so that the whole thing is managed and you don't get any nasty surprises, and you don't find yourself having to tell the client that you've had a massive bill from an expert witness, which ultimately that client is going to have to meet. So communication is key. Your witnesses should be on your side or on your client's side, so they should be amenable to a candid discussion about what their costs are likely to be. And you want to try and minimize those costs, obviously, but that might involve taking practical steps like finding out when they're available, having them at the end of a phone line. That's always a good one. Work out how long it's going to take them, or ask them how long it's going to take them to get to the court building, so that you can give them plenty of notice, but that they can get on with work in the office and they're not hanging around at court. Tell them they have to vouch their costs. Tell them that there are restrictions on costs, that there are caps on how much are recoverable from the opponent by your client in relation to witnesses. As regards expert or skilled witnesses, even their costs have to be reasonable. So just explain that witnesses are not allowed just to give you any amount they're looking for. They have to be, the costs have got to be reasonable, and they have to be vouched as well, particularly with things like accommodation costs and subsistence costs. So we've dealt with what we dealt with. Shorthand writers, dealt witnesses, sheriff officers. What about interpreters? Now, bear in mind, interpreters are not supplied by the court in civil proceedings. They are in criminal proceedings, but not in civil proceedings. I think for human rights reasons they have to be provided in criminal cases, but that doesn't apply in civil actions. So you have to make an assessment as to whether or not you think an interpreter is required. They are analogous to shorthand writers. They take the oath de fideli administrationis, the oath of fidelity, that they've got to be faithful to their duties of being a true and honest and reliable interpreter. So they get put on oath to that effect by the sheriff. They're quite analogous in some ways to shorthand writers, interpreters, but I'm not aware of any rule that makes solicitors personally liable for their costs. But of course it's the solicitor who instructs them to attend, so in that sense you've got a contractual obligation with them. And I don't honestly think you'll get very far if you try and argue with an interpreter. Well, I'm acting for a disclosed principle and I'm not personally liable. I really don't think that would take you very far. So what I'm saying is, if you do have an interpreter there, again, find out how much their costs are likely to be. And I get that you don't know how long the proof's going to last, so you can't always estimate it, or you can't expect them to estimate it that accurately, but try and get an idea, and make sure that you've got the funding up front to cover those costs in advance. Similar thing about personal liability: experts instructed but not actually cited. Now, my view there is, for what it's worth, my view is that you're not personally liable, but there could well be circumstances where you are. There is a case reported on the Scottish Courts and Tribunal Service website, White, WIGHT Chiropractic Clinic Limited against Corries Solicitor Scotland, 12th of October 2005. That was one. There was a debate before Sheriff Scott, before he became Sheriff Principal, of course, Sheriff Scott, Craig Scott, and I was in that case. I appeared for the defender in that case. I'm not going to go into it in too much depth, or in any depth, but it was all to do with whether the solicitors were personally liable for the costs incurred by a company that employed the witness. They'd cited the witness, I think. They'd cited the individual. They hadn't cited the company, obviously, and the question was, did the citation of the individual make them liable personally for the costs of the company? Anyway, it's worth having a look at. However, it will only take you so far, because it's quite a technical argument. What you really don't want is a situation where the company or the individual or anyone else runs off to the SLCC, complains about you because you've got them into a situation where they've incurred expense and they can't get paid. So again, whether you're personally liable or not, assume that you are and get the funding up front to cover that liability. Now, the next one I'm going to mention is the Sheriff Clerk looking to you to pay court fees. And I've given talks about this before and described it as a grey area, but actually it's more like a very dark grey or a very light grey, depending on which way you look at it. It's probably safe to assume that you are personally liable. There is no specific rule to that effect that I know about. So in that sense, it's not like the rule, the situation with shorthand writers or witnesses, where there are specific rules. There's no rule in the court books or anywhere else that says you're personally liable for court fees. There is, in McPhail, reference to a Court of Session case from 1843, which is AB versus CD. Now, I don't imagine that's even real initials, is it? That's just ABCD. 1843. These cases usually involve something of some subject matter that's considered delicate, I think. I don't know what the reason is for this, but anyway, AB versus CD, 1843, Court of Session. That's authority for the proposition that solicitors are personally liable for court fees. Court of Session case. Now, it's Court of Session, it's in our house, I think, so it's binding. It is a legitimate authority. It's as binding as any of the rules. But I do think it's unsatisfactory that we're dependent on a early Victorian inner house case for the proposition that solicitors are personally liable for court fees. But as I say, I think it can safely be said that you are personally liable. Bear in mind, that court fees can be very, very high. I remember when you didn't get charged anything for proof. Whereas now, a 2-day proof could cost hundreds of pounds just in court fees. And of course in the court of session it's even more ludicrous. Court fees in the court of session are just crazy, I think. But anyway, they are what they are, and assume that you're personally liable and make sure that you get the money up front to pay for them. Some court fees, of course, you won't get anywhere until they're paid. So, technically the Sheriff Clerk might refuse to call the case if there's unpaid fees. And it's never a good look where that happens. So avoid the logistical issues, assume that you are liable, and make sure you get the funding to cover that. I'd mentioned as well that you could be the recipient of third party, your client could be the recipient of third party funding. For example, legal aid board or an insurer. Now, I don't intend to go into the whole area of legal aid because that's a whole subject in itself, but I do think that I've got to observe that the risk of being piggy in the middle is a much higher risk where your client's in receipt of legal aid, because you simply can't get the money up front there. You're having to pay out, or you're having to pay out and then get the money back from the board. So you're paying the witnesses, the experts, the shorthand writer and all the rest of it, with your fingers crossed, hoping that you'll get reimbursed by the board within a reasonable time. And there's not much you can really do. You just have to make sure that your cost ceiling is high enough that you get sanction if you need sanction, and always always err on the side of caution and get sanction even if you don't need it, and just hope for the best. People will not charge less because your client is an assisted person. So as I say, if you are acting for an assisted person, make sure you've got sanction, make sure you've got an adequate cost ceiling in place so that you're minimising the risk of getting let down by the board. The only good thing, I suppose, is you're not liable for the court fees because there won't be any. Your client's exempt, so there's that benefit, I suppose, but it's probably the only one. I would say, however, if you're acting for an assisted person, you've got duties under Regulation 24 of the Civil Legal Aid Scotland Regulations 2002, headed Duty to Report Abuse of Legal Aid. If you have reason to believe that the assisted person has unreasonably required the cause to be continued, you've got to tell the board. And that duty overrides any duty of confidentiality that you have to the client. So the rationale behind that, I think, is that clients who are private payers can waste their own money if they want to, but assisted persons are not allowed to waste public funds, and that's absolutely correct. No one could argue against that. You can waste your own money, but you can't waste taxpayers' money. So that's why that rule's there, I think. Okay, the last one that I mentioned was being the colleague of your client's opponent. There can be a conflict between advancing your client's interests and trying to avoid your colleague getting into bother, right? So say the other lawyer has forgotten to do something or has made a mistake. Do you tip them the wink? Do you take advantage of it? This is quite a tricky area. It's hard to generalize about what you should do. The only thing I would say is that clients come and go, whereas your colleagues, on the whole, don't come and go. They tend to stay, and they'll quite often have long memories. I mean, I still remember getting blindsided. I did a debate, an appeal, it was, in front of Sheriff Principal MacLeod, and at that time, this is years ago, this is before any notices or notes of points of appeal. You could just turn up and make your points there and then, and you didn't have to intimate authorities or anything. I mean, it was crazy, really. That was in the days when a debate, there were no Rule 22 notes, so you could turn up at a debate and you had no idea what the opponent's points were going to be. Not a great system, but anyway, that was years ago, as I say. That was about, when was that? Early 90s. But anyway, I still remember somebody pulling an authority out that completely torpedoed my guy's case. Now you might say, well, I should have been aware of the case, but I think it had only just come out, and it's pre-internet and it's not as easy to get hold of information in those days. But I still remember to this day getting turned over like that, and maybe I should get over it. I shouldn't be so bitter, but I do remember things like that, and I'm not alone, because I know that other solicitors feel the same. So don't try and pull a fast one on your colleague. There isn't really any advantage to it. I know you might be serving your client's interests, but you don't want to fall out with people. It's a very small profession in Scotland, and bear in mind your reputation is important, and you don't want to be regarded as someone who's sneaky or a smart aleck or anything like that. So try and have regard to your fellow solicitors. It's a difficult job we're all doing, and I always say that it's just fate that you're acting for your client and not the other client. The other client could have come to see you instead of whoever they have gone to see. There's no, bear in mind, we shouldn't be taking these things personally. Keep a distance, professional distance, and treat your colleagues well and respectfully. Right. You'll be glad to know I've kind of finished with risk management, and I'm going to move on now to a topic or a heading which is to do with managing evidence. However, as a preliminary matter of management, I'm going to touch on the question of hearing parts of proofs separately. Now, this is specifically permitted by the rules. It's in the Court of Session chapter, it's Rule 36.1. In the Sheriff Court, in the Ordinary Sheriff Court, it's Ordinary Cause Rule 29.6, and this specifically allows the court to hear parts of a proof separately. This can be a sensible thing to do in terms of saving time and money. The rules, the annotated rules of the Court of Session, in other words, that book there that I recommended, it refers in there to two instances where you might want to have a separation. One of them is in a personal injury case, where you would have a proof on liability, and then, of course, if liability is established, you would have a separate proof on quantum. You would only have the proof on quantum if liability was established, of course. If you didn't, that would be the end of it. So, sensible instance where you would have a separate proof on quantum, and before that, of course, would be the proof on liability. I would say that most personal injuries cases I've done that have gone to proof, they tended not to be separate, but it is something that you can do. The other example that's given in the annotated rules is where there's a preliminary proof, or, well, preliminary proof is where there's an issue raised in the pleadings which could bar the action from proceeding, right? And the annotated notes say that these are three in nature. Firstly, where there's a plea of no jurisdiction. Secondly, where there's an issue of bar, so that could be personal bar, it could be time bar. And also where there's a challenge to title. So if someone is suing in a particular capacity, as an executor, for example, and that capacity is challenged, then it would make sense to have a proof on capacity before moving on to anything else. Another scenario that I've encountered where you would have a separate proof is in relation to a divorce action where there's a dispute about a relevant date. I've had one of those recently, and you need to know the relevant date before you can then start valuing and ascertaining and quantifying all the matrimonial debts and assets. And usually, now 9 times out of 10, probably even more than that, you would have agreement on the date of separation, the relevant date, but sometimes you don't. And in that case, you have to have evidence about it, and it makes sense to have that evidence out and the relevant date established before you move on to anything else, so that you've got a fixed point where everything crystallizes. So let me move on from the question of hearing parts of a proof separately to managing the evidence that you need to succeed at a proof. Now, in my opinion, there are really 3 forms of evidence. You've got real evidence, documentary productions, and then you've got oral evidence from witnesses. Technically, there might be a 4th, which is a locus inspection, but they hardly ever happen, in my experience, hardly ever. In an ideal world, you would have a locus inspection in every road traffic proof on liability. Excuse me. What would happen would be that the sheriff would go and look at the junction or the roundabout where the accident had happened. That would be the best evidence, but of course that would be expensive, so that doesn't happen. The only case I've ever actually had with a locus inspection was a lands tribunal case, which I think is standard practice in lands tribunals. The tribunal will go and look at the locus, but it's not done in the same way as it's done in the court, in the sheriff court, because in the sheriff court my understanding is that the agents go with the sheriff to look at the locus, whereas in the lands tribunal that doesn't happen. They just go along and have a look, and you're not there. So it's different. The lands tribunal one, it was to do with a servitude on a bridge or a rickety bridge over a wee river up in the Highlands, and the tribunal went and had a look at that, but I wasn't there. But in the sheriff court, highly unusual to have a locus inspection. But anyway, so 3 types. Real evidence. So this is basically anything apart from documents that you show to the court. So these are lodged in advance. Usually you'll find that the sheriff clerk does not want to store your real evidence, particularly if it's bulky or if it's valuable. The sheriff clerk doesn't want to have to find a place to store anything really that isn't paperwork. And I'm not saying they're unhelpful, but the sooner you lodge real evidence, the better. That's another thing I would say. COVID impacted on how that kind of evidence was processed, just so far as it affected so many things. But now it shouldn't be such a problem. I've used real evidence in a number of cases, and I'll tell you about those. So I had a case involving a fur jacket a mink fur jacket, and how robust it was and how it came to be damaged. There were allegations that it had been ripped in a fight. There were allegations that it had split when it had been put on. I acted for the furrier. Is that what you call him? Furrier? The guy that made the jacket? He was very indignant that his workmanship was being called into question, and we had a proof over how this fur jacket had come to be damaged. And I produced the fur jacket, which was examined by the sheriff on the bench. So that was useful. The sheriff actually examined the garment. I had another one involving a cartoon menu featuring a cartoon character called Wee Dougal, his Highland Terrier. His name was Hamish. This was used at a cafe in the Trossachs, and we produced the menus. There was another proof I did involving an alcoholic drink, which was a mixture of vodka and pomegranate juice, and there were promotional bottles for this beverage, so we produced bottles that were examined by the sheriff. I also had a case involving, I don't know if you remember, but Glasgow was European City of Culture way back in 1990, and I acted in a case involving merchandise that was produced in connection with that whole project, and that involved lodging t-shirts, key rings, pens, and stickers, car stickers, all showing us a particular design, a particular logo. I had a case involving a plastic chair that incorporated the logo of the pub in the beer garden of which these chairs were displayed. These are all examples of where photographic evidence isn't really as effective. I could have taken photographs of the chair or of the coat. I keep calling it a coat. It wasn't a coat, it was a fur jacket. But there's more impact if you actually get the real object there. On a related subject, although I mentioned photographs, are photographs real evidence? They probably are. They're a kind of cross between real evidence and documentary evidence insofar as they usually show pictures of things that aren't documents, like locuses or injuries or things like that. Video evidence as well, that can be very effective. I've had cases where I've used video evidence. I had a divorce action in which there was a homemade pornographic video cassette. I've used a DVD of someone tipping out the contents of a rubbish bin in an antisocial behaviour case. I've used video evidence of drug dealing at a flat. That was in an eviction action. Now, all this evidence I've mentioned can be very effective and it can have great impact. I once had going back to mentioning about employment tribunals, I once had an employment tribunal where a barmaid claimed that she had been sexually assaulted by one of the owners of the restaurant where she worked. And her initial statement was very brief and very vague about detail, but she gave details subsequently in a supplementary statement in which she identified locations on the premises and times and days when this had happened. However, I acted for the restaurant owners and they had retained CCTV footage which showed dates and times, and the CCTV footage showed that the allegations were false insofar as what the barmaid said had happened at a certain location at a certain time had not, because the CCTV evidence showed she wasn't even there, or she was somewhere else at that time. So it was an incredibly effective use of the evidence, because she threw in the towel. She chucked the case, and basically, I think, admitted that it was fabricated. So didn't even need to go to proof. But it's just lucky that my clients had kept that footage. If you are going to use video evidence, you need to ensure that you've worked out how to show it, how to use it. This used to be a bit of a problem, years ago. Particularly I'm talking about the days of video cassettes. Sheriff clerks, generally speaking, were a bit wary about video evidence. They're nowhere near as squeamish about it these days, but at one time it was quite tricky to get them to accept video evidence, because there was always a problem about how to show it, and there were certain logistical issues, but they're nowhere near as bad as they used to be. So to be honest, it's probably not as bad as it was before. Before you would bring your own equipment and it'd be told you can't use that, it has to be checked for health and safety, and you would then say, well, this is in the old days, you would then say, well, have you got equipment that can show this? And it would be, I need to speak to so and so, and it was just, particularly in smaller courts, it was always a bit of a problem. But nowadays it's not so bad, but you do have to be quite well prepared, so the sooner you speak to the court about it, the better. Audio evidence as well. I've never actually used audio evidence, but I have come across it being used at a child welfare hearing. I did a child welfare hearing. Now technically, of course, they're not proofs, and technically there's no evidence at a child welfare hearing. Not a standard one anyway. But there was a recording of the father basically coaching the child to say things, basically trying to cause trouble, but it was all recorded and it was played. I mean, it was just absolutely cringe inducing, particularly because I acted for the father. I mean, how on earth do you react to that? That was a difficult one. But again, audio evidence, certainly there, I'm using the term evidence loosely, can be very effective, just like video evidence can be very effective. Text messages, you would print those out, you'd lodge them essentially as documentary evidence. Talking of documentary evidence, I have seen numerous problems arise in relation to these forms of evidence. The proof that I had last week in Kilmarnock, it turned out that my client's opponent's lawyer hadn't seen an inventory of productions that I had lodged ages ago, and she'd lodged an inventory of productions that I hadn't seen, and this all came to light on the day. And in my experience, that happens quite often. The other thing that can happen is there aren't enough copies, so be prepared. Check in advance that you've seen everything, particularly if you're dealing with party litigants, and just be prepared. There's not really much more you can say about it. I mean, at one time you could go along to the court and actually look at the physical process, and you could check how many productions there were, how many inventories and so on. It's not as easy to do that these days, and so many things now are lodged electronically that there isn't going to be a physical manifestation of that document or whatever it is until the day itself, when you are expected to show up with hard copies of all these productions. I'm not sure it's a great system, to be honest, but that's the one that we're kind of having to deal with. But I'll come on later on to physical documentaries, but documentary evidence. I would say at the present time that in principle, whether it's electronic or hard copy documents, there is a certain skill in deciding what to lodge and what to omit. So the example that I usually give for this is if you've got a bank statement that's 40 pages long, but it's missing page 22, for example, your opponent and the court are bound to ask themselves, what is on page 22? Why is that not there? In other words, you're drawing attention to that page by its not being there. If there's something on that page that you don't want anyone to see, fair enough, but don't just leave that one page out. Leave out other pages, or even better, try and lodge maybe just one or two pages rather than a long bank statement that contains the real evidence that you want the court to have regard to. So use samples, but try and avoid drawing attention to a missing page, because that is bound to be noticed. The other thing I would say is there's a temptation to lodge absolutely everything that you think you might need. It's the same as, I suppose, pleading everything that you might need to rely on, or including in a witness list everybody that you could possibly think of that you might need to call. And it's really to do with being safe, insofar as if you've got a name on a witness list, you're entitled to call that person. If the name's not on the list, you're not, unless with leave of the court, and you don't want to be reliant on that. So you put in every Tom, Dick and Harry you can think of, which is safe, the safe thing to do. But bear in mind that if you do that, then there can be adverse effects in terms of costs, because if you put somebody's name on a witness list, you can't complain too much if your opponent wants to speak to that person. In fact, that's really the purpose of the list, isn't it? You're giving notice of who you're intending to call or likely to call. That immediately makes them fair game for inquiry by your opponent, who may go and precognose that person. And if your client loses the action and has to pay the opponent's expenses, then those expenses will be higher because of the extra work that the opponent's solicitor has had to do as a result of your lengthy list of witnesses. And of course it's the same with productions. The more productions you lodge, the greater the costs that can legitimately be incurred by your opponent in reading those productions or looking into them. So it's not, it is safe to do it, to put in absolutely everything, but at the same time it also bumps up the costs if you lose. Also, though, in terms of lodging productions, you don't really want to let your opponent know that you've lodged everything you've got. You always want your opponent to think that you might have something else up your sleeve, I think. Just to keep them on their toes, you want them to think that you might have something else. If you lodge absolutely everything, then they know you don't have anything else up your sleeve. So don't lodge everything. Productions as well have got to be user friendly to the sheriff, and particularly to any witness who has to speak to them. If the witness is remote, again, this isn't so much of an issue these days as it was maybe 3 years ago or 5 years ago. If the witness is remote, you have to deal with getting those productions before that witness remotely, which can be a challenge. It's nowhere near as easy as simply having the witness in a witness box and then you just hand them up the pieces of paper that you want them to look at. Particularly some witnesses who are maybe not technologically minded. But anyway, that's not so much of a problem these days. What I would say is that if you are lodging lots of productions, try and follow some kind of system, have some sort of method for organising them. So for example, if you've got a building dispute or a dispute involving a course of dealing, course of transactions, have some kind of system. So if it's a set of invoices, delivery notes, receipts regarding a building claim, either lodge them chronologically or by the names of the suppliers, B&Q, Juicens, whoever it is, keep them together, or arrange them by the type of document, so all the invoices, then all the delivery notes, then all the receipts, some sort of system, just to make it easier for everyone to follow where you're going with the evidence. Now, there isn't any requirement in the rules to do this, and sometimes you might not have time to do it, particularly if you're having to get an interim interdict and you're having to sort of throw everything together in a hurry. But generally speaking, you will have time to do it, and just try and make things a bit more ordered. Check before the proof that your productions are all numbered, that they're in order, that there's a copy for the sheriff. And as I say, I've lost count of the number of times I've had problems with productions in proofs. And as I say, just last week, turned out I didn't have an inventory, the opponent didn't have my inventory, and they were important documents, particularly my productions, which were quite voluminous, and I intended to go through them at length. The proof went off, as it turned out, but had it gone ahead, they would have been an integral part of the case, and I'm convinced that the other side would have required an adjournment to take instructions on them, and I'm not even convinced that she could have got the instructions that day. The proof may have had to go off to another day. Again, logistic issues, try and check that everything's there, saves time, avoids panic, makes you look more professional, gives a better impression. If you've got a production that's a dozen pages long and the pages aren't numbered, then number them, and that way you can refer the witness or the court to a particular page or passage quite easily, and you don't have the witness flapping about trying to find that page or passage. Bear in mind that witness boxes are not the best in terms of the amount of desk space that they have on them. They're generally far too small. You've got witnesses trying to perch paperwork on the edge, maybe an edge that's only like 6 inches wide, and papers can get out of place, they can drop onto the floor. I've seen that happen a few times, and it doesn't look good and it wastes time. So try and make the productions user friendly. Think as well about whether you need to lodge a production, and if it's the right production you're lodging, and if it's copies, can you get away with lodging copies? Some documents, of course, are what they used to call probative, now called self-proving. So, for example, a land certificate is probative, a letter is not. So if it's not probative, you need someone there to speak to it unless it's agreed, or unless you've served a notice to admit that hasn't been countered by a notice of non-admission. I'll maybe come on to that later on. Make sure that you link the witnesses to the production so that you not get any gaps. So for example, if you've got a breach of missives case involving a defective central heating system, your client has probably engaged the services of a plumber, and you would probably lodge there something like an invoice or an estimate from the plumber. Now, your client can certainly say in evidence, that's the invoice or that's the estimate I got from the plumber, but remember, that's not really going to take you much further than that. So if there's a challenge about the quantum of the claim, you need the plumber there, not just to say that's my estimate or that's the charge that I levied, but you also need evidence that that's a reasonable charge, and you would need the evidence of the plumber, or even better, from somebody else, to say that it's reasonable. So try and be clear in your own mind as to what it is you're trying to prove, and then think about what you need to do to prove it. And that might involve a bit of expense in terms of bringing along, as in that example, another plumber. But there isn't any proof. There's no point in just having evidence that your client got a bill. You have to go further than that and say that it was a reasonable bill, and that requires evidence from somebody other than the client. Take copies of your own, and what I always do is I always tab them. Which is something that, when I say I always do this, I only started doing it not that long ago. But what I basically do is I put a coloured bit of paper protruding from the edge, and I write the process number on it, the production number on that piece of paper. And it's remarkable how easier it is now to find productions than it used to be. I don't know why I didn't think of that before, but anyway, that's what I do these days. Going back to sheriffs getting annoyed, you'll sometimes find that sheriffs get impatient because you don't agree evidence, and whether they're legitimately annoyed depends on the circumstances. I mean, it rests entirely on whether it's reasonable and sensible to agree evidence. For example, suppose in a family case somebody lodges a statement of an account with Virgin Money. It's pretty unlikely that that's a fake. I'm not saying it isn't a fake, but it's pretty unlikely. You'd be expected to agree that. And if you don't agree it, you'd have to have a fairly good reason as to why you were not agreeing it. If, on the other hand, the production is, say that was that plumber's bill, and say the plumber happened to be a cousin of the client or the opponent or whoever, someone that was involved in the case, you wouldn't be expected to agree that, or you certainly wouldn't be expected to agree the accuracy or the reasonableness of the information within the document. So it depends entirely on what the document is as to whether or not you should be agreeing it. Some sheriffs will pressurise you into trying to agree things. These days as well, you'll be aware that the court rules give the sheriff far more powers to be proactive and direct that things be controlled in certain ways, and that you have to lodge affidavits, or you have to do all kinds of things, call certain witnesses or dispense with witnesses. It's not a trend that I particularly like, because I think that once you take control of the litigation away from the solicitors, you're leading to all kinds of problems about who's responsible for the conduct of the case. You can't expect solicitors to take the rap for aspects of the preparation and presentation of a case when they don't have control over those, where that control is taken out with their hands and given to the court. I think it gets messy. But anyway, yeah, sheriffs will sometimes put pressure on you to agree productions. Remember, you can only do that in your client's instructions, so never do it off your own bat. Think as well about if it's the opponent that's wanting you to agree productions. Think about why they're wanting you to do that. It's almost certainly because it helps them, in which case it disadvantages you. Why make your opponent's job any easier? It is an adversarial system that we work within, and You are there to defend and protect and advance your client's interests. So don't just agree things for the sake of it. Take instructions, and don't just, as I say, automatically do it. Don't do it by default. Think about why you're being asked to agree productions. I once had a proof in Falkirk Sheriff Court, and it involved work undertaken at an industrial unit. One of those elements of work was quite small overall, proportionally compared to the claim. It was an invoice for about £1,500, and I was asked to agree a whole lot of things, including that head of claim, and took instructions on it, and I didn't agree anything. What then happened was, at the proof, the opponent's solicitor forgot to ask the client about that particular invoice for £1,500, and as a result of that, that part of the claim was not awarded in favour of the opponent. In other words, solicitor messed up and didn't ask about something which it probably was the case that money was due, right? But he forgot to ask about it. I hadn't agreed it, and it was therefore excluded. So that was to my client's advantage. Now, if I'd agreed that invoice, that would have cost my client money, because that head of claim would have been successful because it was admitted. So, as I say, don't automatically agree evidence just because you're asked to do it. Take instructions on it, think about it, and then take a decision. Now, you might say, well, are there any advantages to agreeing evidence? Well, one thing is, if it's obvious, if it's like the bank statement, then you'd be expected reasonably to agree that. It saves time, saves cost. There's also the question of reciprocity. If you agree some of your opponent's productions, you're in a better position to ask that the opponent agree some of your productions, and that will save time and expense all round. So, for example, you don't have witnesses coming along to speak to productions that you've agreed, and that will cut down on time and expense. So in the instance, for example, of the bank statement, I mean, if that isn't agreed, then technically you would have to bring along an official from the bank, and if you were in a situation of having to do that, you can imagine the sheriff would get very annoyed about that, and quite rightly, because that's just wasting somebody's time having to bring them along. Yeah, as I said, courts now have got far more power to control evidence. So the one I'm looking at here, Chapter 33AA, expeditious resolution of certain causes. This isn't in the ordinary cause rules. Sheriff can restrict issues for proof, exclude specific documents, reports and witnesses from proof. This is in relation to contact orders, in Section 11, orders relating to children. But I think that's the way that litigation in general is going, and I think it will continue to go that way. Right, let me speak now about witnesses. The COVID legislation, as I said earlier, it tries to dispense with physical attendance and move to a system of remote means of attendance. And there was a whole mass of guidance notes and sheriff principles, practice rules and all the rest of it dealing with this. And I remember that you had to check which sheriffdom you were litigating in and check that sheriff principles guidance about attendance of witnesses, because they weren't all the same. Nowadays that's all kind of in the past, so these days, you cite your witnesses and they attend court. As far as witnesses are concerned, communication, as with so many things, is so important. You have to make sure that your witnesses know why they're there. That doesn't mean that you coach them. It doesn't mean that you tell them what to say. It means that they understand what their role is in the proceedings, both in terms of what they have to do and why they're there. What you'll generally do is say to them that they know something, or they're in possession of some kind of information that is valuable or is relevant or pertinent to the case. Before they even get to court, I know that some solicitors get witnesses to sign their precognitions. I think that's a good idea. I don't do it myself, but I know some people do that. Or you can send your precognition to the client, to the witness, which is a good idea as well, because it means that if there's anything that's wrong, then the witness can correct it. If it's a really significant statement, then you can get an affidavit. I had one where there was an allegation that a solicitor had committed a fraud, so I get an affidavit in that one. The other thing that you can do is you can precognose the witness and get a colleague in the office to precognose the same witness separately, independently, and that way, of course, you're lessening the risk that you're taking something down wrongly. You know, that's a useful thing to do as well. I've done that before. McPhail says that you should always precognose one witness out with the presence of another, and that's in there at 1511 to 1515. So you should certainly read that. Very important to do that, because you don't want a situation where you've got the client and a friend in your office at the same time, and they're both sort of chipping in, and you're trying to write it down, and you've got a file entry which you then try and manufacture into or transform into a precognition, and you're not quite sure whether something that you've written down was said by one person or the other, or both. And if you've only got one person there, you know what they've said. You know it can't be by anyone else, because they're the only person there. So precognose clients and witnesses on their own. For one thing as well, they're not going to be influenced by what someone else says. And of course, when they're in court, they're going to be giving evidence on their own. They're not going to have somebody there, giving them a nudge or telling them what to say. So we've already dealt with the fact that if you cite a witness, you're personally liable for that witness's costs. Cite them in plenty of time, and get in touch with them again nearer the time of the proof. What to do is try and remind them of the court they're going to, because the last thing you want is someone going to Airdrie instead of Hamilton. Remind them which court it is they're going to. Get their phone number. Tell them that tell them the logistical issues. The nearest railway station at Hamilton Sheriff Court, for example, is Hamilton West. So get off at Hamilton West and walk down through the retail park. Hamilton, of course, has got two buildings, one of which is used solely for criminal work, I think. Beckford Street, the civil work is all dealt with in a sort of separate annex. Clients won't necessarily know any of that, so you don't want them going to the wrong building. You certainly don't want them going to the wrong court. So, and the thing as well is that if they do go to the wrong place and they get directed to the right place, they're not going to be happy about it. They're going to be flustered. They're going to be maybe annoyed. So to keep them in a good frame of mind, just tell them where they're going, and to take plenty of time to get there. Tell them also that these things don't just kick off at 10 o'clock. I mean, how many times have you ever had a proof that starts at 10 o'clock? It virtually never happens. It has happened to me occasionally, but 99 times out of 100 it starts half past 10 if you're lucky, sometimes 11 o'clock. So tell the client that they may have a long wait, that they might want to bring Sudoku or something, or a book, and they should meet you somewhere specific, like inside the front door of a particular court at a certain time. Make it half an hour before the proof's due to start to allow for, delay and transport and so on. What about dress code? Well, witnesses sometimes ask about this, and what I just say to them is just look smart. So that shows respect to the court. You don't want somebody turning up in, football colours. You don't want them turning up in a white tracksuit. It doesn't need to be a suit and tie, but it does need to be quite smart. And the other thing, of course, is you don't want mobile phones going off. So tell them to make sure that doesn't happen. That can really annoy sheriffs when that happens. Tell witnesses and your client not to use your first name. I think that looks terrible when the client or the witness uses your first name. I just think that looks awful. Explain to the witness that they have to go into the witness box, point out where that is, say that they have to take the oath and then answer questions. It might seem obvious to us as practitioners that that's what happens, but most people, you need to remember, most people have never been in a court in their lives. So they need to be put right as to what's involved. They should be told as well about the fact you can't ask leading questions. Leading questions, of course, are questions that indicate the answer that you want the witness to give. So tell witnesses that they've got important information that they need to impart, but they have to do it in their own words, that they should give expansive answers, that you're not allowed to prompt them or lead them. And as long as they understand all that, there shouldn't be a problem. You never know, but you have to do these things. Remember as well that once the witnesses are there, they have to be kind of isolated, and in particular a witness who has given evidence isn't allowed then to discuss that with someone who's yet to give evidence, and that includes the client, of course. McPhail has got a chapter about management of witnesses, and it says in there it's a duty of solicitors to see that all witnesses are enclosed in the witness room. Well, that's assuming there is a witness room. I mean, some courtrooms don't have a witness room. For example, Court 9 in Glasgow doesn't have a witness room, and quite often there are proofs in that court and the witnesses are milling around in the corridor outside. I never think that's a good idea, but if there is a witness room, use it. Do not, or at least witnesses should be told, don't discuss a case while waiting to give evidence, and certainly don't disclose the evidence that they've given after they've given it. Don't let them mix. I mean, it's difficult sometimes if you've got say it's a family case and the client's there with her mother or her sister or whatever, and everybody's a bit distressed. It's difficult to keep them apart, but you really have to try and do that. And not only that, you have to be seen to be doing it. And I always try and make sure that I am very audible when I say to clients, or witnesses rather, do not discuss anything that you've said with anyone who is yet to give evidence. Make sure that you make it clear that you've done your best to try and ensure that there isn't any sort of breach of that rule. Sometimes the sheriff will say that, which is good. That's helpful if the sheriff says it as well. But do what you can. Try and ensure that you're seen to be doing it. Problems can arise if the proof's adjourned to another day. particularly if somebody's in the middle of giving evidence, and you then sometimes have a situation when we say it's a month later. Do you have a meeting with a client in the meantime? Well, there's something in the annotated court of session rules about that. It says in there that counsel and agents may not discuss with a witness during an adjournment the evidence he is giving. So, in my opinion, that includes the client. So, yeah, you could have a meeting with the client in that situation, but ask yourself whether that's wise. Probably not. Let me move on now to the question of vulnerable witnesses. Now, the rules of court are absolutely full of references now to vulnerable witnesses. Years ago, there was nothing about vulnerable witnesses in the rules. But now, the sheriff is supposed to inquire as to whether any proposed witnesses are vulnerable. I don't think I've ever seen that happen. Witness citation forms advise the witness that if the witness considers himself to be vulnerable, he should tell the solicitor who cited them. I don't think that's ever happened to me. I don't think anyone's ever said they're vulnerable. I have had situations where there have been vulnerable witnesses though, and in my experience, sheriffs are very good at dealing with vulnerable witnesses. So, and they're quite pragmatic. So, for example, I had a proof in Dunoon where one of the witnesses was a wheelchair user, and I don't know if you've ever been in Dunoon Sheriff Court, but last time I was there was only one courtroom. It was upstairs, and there wasn't a lift. That might have changed, I don't know, but at that time the only way of getting to that courtroom was going up the stairs, which my lady in a wheelchair wasn't able to do. So what we did there was we heard her evidence in the Sheriff Clerk's office, which was on the ground floor, and that was fine. It was okay. I also had a proof in Airdrie where all the courts are on the ground floor in Airdrie, but the problem again was that the lady was a wheelchair user, and it just wasn't possible to get her into the witness box. So she just gave her evidence beside the witness box from her wheelchair. And again, no problem. I don't think I've ever had any problems with dealing with vulnerable witnesses. As I say, sheriffs are generally very good about it. So, let me deal now with intimating and lodging lists of documents, witnesses, affidavits and productions. Now again, COVID had quite an impact on this. Let me just put this over there. And generally speaking, the whole kind of impact of that was that the Sheriff Clerk didn't want you lodging hard copies of anything, and that is still the case, to the point where even writs now, you don't lodge them physically, initial writs. The only documents that you really lodge physically now are commissary papers, C1s, that kind of thing. So physical documents, they generally don't want you lodging them, but as I said earlier, when you turn up for the proof, you're expected to bring with you physical copies of, well, in my experience, physical copies of everything. So that's pleadings, the record and so on, and also all the documents and lists of witnesses and so on. So whether you're doing the lodging physically or doing it remotely, you do have to have regard to the time limits, because these are the same regardless of the method you use to lodge your documents. Now, in practice, a great many solicitors, in my experience, completely ignore time limits, and a lot of sheriffs do as well. Sheriffs will quite often say, if something's late, the sheriff will say to himself or herself, and we'll say in court, is anyone prejudiced if this is let in now? Right? Prejudice is the test that they'll apply in practice. They won't say, this is late. Why is it late? In my experience, they don't ask that. However, bear in mind, they're quite entitled to ask that, and they probably should ask that. So do not assume that you'll get away with lodging things late. We're all very kind of lax about this, but never ever be complacent, because you just don't know. You don't want a situation where the sheriff refuses to allow something in because it's late, because it's your fault if that happens, usually. And party litigants in particular will quite often object to anything that's late. And although the risk of not being allowed to lodge something due to lateness is pretty slim, particularly if it's only just late, the consequences could be quite dramatic if something is refused. So the risk is probably small, but the consequences are quite substantial. So please try and stick to the rules about time limits. Never ever assume that you'll get anything in late, because you may be unlucky and you may find that something isn't allowed in late. The sheriff has a dispensing power. In my experience, it's used quite a lot, probably far more than it should be. But do not assume that the dispensing power will be used in your favour. You should never ever have to rely on that. Always try and adhere to time limits. I mean, the other thing I would say about it is the time limits are actually they're not too demanding. I mean, it's not too much, in my opinion, to expect that productions be lodged 4 weeks before the proof or whatever. You should be able to comply with time limits. So always try and do that. Courts, in my experience, rather than if there is prejudice, by the way, in something being lodged late, courts will generally, rather than refusing to allow it in, they will allow it in, but they'll put the proof off. And then, of course, that gives rise to the question of who's liable for the discharged proof. Chances are it will be your client or you, neither of which situation you want. So my point, I suppose, is that don't lodge things late unless it's absolutely unavoidable, because the consequences can be quite unfortunate. Allied to that is always check the rules about time limits. I get caught out with this recently in relation to a taxation of expenses, where seemingly objections had to be lodged 15 days before the hearing, and I didn't know that. I should have known that, but I didn't know that. And now the objections are in late, and the hearing hasn't taken place yet. But I'm going to have to rely on the auditor allowing those in. So not a good situation to be in. But again, that's due to ignorance on my part. I should have checked that. So, as I say, look at the rules, because they're full of time limits. In the ordinary cause rules, you have to intimate, this is another thing, the time limits can sometimes operate from different points. So in the ordinary rules, you have to intimate to your opponent within 14 days of the interlocutor allowing the proof a list of the documents that you're going to use at that proof. So these are documents rather than productions. It's written material that you are yet to lodge as productions. So you don't actually lodge anything, you have to intimate a list. This is in terms of ordinary cause rule 9A2. In addition to that, you've got 28 days from the interlocutor allowing proof to intimate a list of witnesses. So again, you have 14 days for this list of documents, 28 days from for intimating a list of witnesses. You also have to get your productions in 28 days before the proof. So what you've got here is you've got different points of reference. You've got the date of the assigning of the proof, and you've got the proof date, and then you've got 28 days, and then you've got 14 days for different things. So again, you have to be careful about this. Make sure you comply with these time limits, and that means checking what they are, and then acting accordingly. Bear in mind as well that there are special rules for particular forms of procedure. I mean, personal injury is a law unto itself. It's got all kinds of time limits in there. So there's a whole load of micromanagement in personal injuries cases, as there is in appeals, of course, these days. So it's the way it's all going, unfortunately. I think there's far too, in my opinion, there's far too much micromanagement of procedure. It's just got out of hand, but unfortunately that's the way it's going. That's what we're faced with, and you just have to be aware of it and mindful of all these time limits. The more rules and regulations there are, the more pitfalls there are, the more risks there are of getting something wrong. So read the rules and make sure they're up to date as well. I mean, I don't think these are up to date. I must buy a more up to date copy of that. But anyway, let me carry on. What are we on? 2.5 hours I've been talking. Right, let me crack on. Notices to admit. I don't know if you've ever used a notice to admit, but you really should use them. I think they're great. I use them a great deal. There's all kinds of good reasons for using a notice to admit. You get paid for lodging a notice to admit. It forces you to prepare for the proof 6 weeks in advance, because you've got to get them in by then. It shows the court that you've done your best to try and agree evidence. You can, of course, instead, or as well as doing that, you can prepare a draft minute of agreement and try and get your opponent to agree what's on the list. So you can do a notice to admit in relation to documents or facts or statements, averments, whatever. But you can also do a minute of agreement as well. The problem with a minute of agreement is, though, until it's signed by both sides, it's utterly irrelevant. It's of no effect whatsoever. Whereas a notice to admit requires that the other side actively negate it by lodging a notice of non-admission. So they have to react to it, whereas they don't have to react if you send them a draft minute of agreement. But anyway, notices to admit I would recommend. Next point I would make is in relation to leading at a proof. In other words, going first. Now, I've seen instances where a pursuer wants the defender to lead at a proof, and that way it's probably because the onus is on the defender to prove something. So it makes sense for the party who has the onus of proof to go first. But generally, it's far easier to lead at a proof than not to do so. And the reason for that is that you don't need, if you're going first, you don't need to worry about putting something in cross-examination. You don't have to worry about putting in your cross-examination something that you're going to be asking your own witnesses about later on, because you've already asked your witnesses. So, put it another way, if you're going second, the other side has already given its evidence, which means it no longer has the chance to lead evidence contrary to your evidence. So if there's evidence that you want to bring out, and in fairness, the other side should get a chance to comment in their evidence about that, you have to let them know that you're going to be leading that evidence, which basically means putting that anticipated evidence to the opponent's witnesses, if it's fair and reasonable to suppose that they might have something to say about it. Now, that explanation I've given is extremely complicated and convoluted and probably incomprehensible. Let me just summarise it by saying it's easier to go first, because you won't have certain issues to deal with that you will have to deal with if you don't go first. I'm going to move on now. This is to do with practical steps, making life as easy as possible on the day. Right. Here's the thing. Do you write out a list of questions or points in advance of the proof? Well, we all have our different methods, but whatever you do, have some kind of structure. For one thing, it's nice to have a safety net. So, some people can cross-examine on the hoof, on their feet, without looking at any notes. But bear in mind that, litigation is an inherently risky business, rarely goes according to plan. Something might crop up that catches you out and you're on the back foot. And it's nice, I think, to have a safety net, which is your set of questions or your set of points, because you can get distracted. And if you've got that there in front of you, you've got something to go back to if you lose your train of thought. Also, I always find that writing out questions or bullet points is a really good way of preparing for a proof. And it highlights things that you maybe hadn't thought about. You work out what you're going to ask, you work out what productions you're going to rely on, you check the productions, you make sure that they are adequate. You work out, am I going to have enough from this witness and that production to prove the point that I need to prove? Do I need another witness? So it kind of thrashes out all these issues well in advance, and you've got time to address them before the proof itself. On the other hand, you don't want to be tied too tightly to a strict script, because things can go off script. It would be nice if you could have a flow chart, so that if witness answers in one way, you go down one flow, down your flow chart, or if he answers a different way, you go down a different flow. But life isn't like that. That's not how things are. They're not as mechanical as that. They're not as predictable. You do have to be able to be flexible, to be able to think on your feet, to be able to deal with unexpected turns and twists, because there will be plenty of those. Witnesses can have a horrible tendency to say things that they didn't say in their precognition, and that can be quite a serious problem. Bear in mind as well that things can happen unexpectedly if, for example, your opponent lodges a production late, or calls an extra witness that you didn't know about and starts exploring a whole line of evidence which you hadn't really had any notice about. So have some kind of basic script to work to. You can sometimes just go through the pleadings, but often that's not enough. The pleadings are too brief. They might not refer to the productions. You might need the witness to develop a point that isn't in the pleadings. So I would recommend you have something, but don't rely on it too much. Just use it as a kind of basic plan to work to. Another thing that you should try and do, if you can, is familiarise yourself with the courtroom where you're going to be conducting the proof. Now, sometimes you won't know which courtroom it is. I mean, I mentioned Dunoon. You know that if you've got a proof in Dunoon, it's going to be in that courtroom, because there is only one courtroom in Dunoon. But in Glasgow, there are, I don't know how many. Well, there's probably 23 courtrooms in Glasgow. Probably more than that now. And many of them are used for civil business. And you might end up in a criminal court. As I say, the one I did earlier in the year was in a summary trial court. But try and familiarise yourself with the courtroom. I remember that I conducted a hearing. It was a licensing appeal in front of the licensing committee of Glasgow City Council, and I had never done one of those in my life, but so I turned up for it, and it was in it's like a courtroom off, is it Cochrane Street, behind the city chambers, and I went in there and I was astonished by that. I just wasn't expecting it to look like that. So I don't know if you've ever been in there, but the councillors there must have been about 9 of them I think it was single figures, but high single figures. They were sitting at a bench that was really high up, a lot higher than I've seen in any court, and it was I thought it was quite an intimidating place, simply because I hadn't been there before. It was unfamiliar, and it just was quite intimidating, and the hearings themselves were quite intimidating. So you had private hire drivers sort of standing there just getting bombarded with questions, and I felt quite sorry for these guys, and some of them were facing allegations that they'd been rude to passengers in their taxis and so on, and the witnesses who were claiming this, well, they weren't even witnesses, they'd put in letters to the council, and these taxi drivers were having to answer allegations, and I thought to myself, how do you know any of that's actually true? These could be malicious claims, but these guys were getting a hard time. So it wasn't an environment that I found very pleasant, but it was a bit of an eye-opener, and I thought to myself, I'm in courts all the time, I know how they work, I know the layout, but for most people, clients and witnesses who take part in court actions, it must be a similar experience to the one I had in the licensing room, chamber, whatever you call it. And I kind of wish I'd gone in there and watched a case being conducted even the week before or whenever, just so I knew what the format was. I would have found it easier on the day if I'd done that. Just a few more points. So be careful what you say in court. I've learned that anything you say in the presence of a bar officer can quite easily be communicated to the sheriff. So just be careful, be discreet. Another thing I would say is quite often, proofs can be quite tense, and you show up at court, you're feeling stressed, you need to take instructions. Quite often the client will have with them people there to support them, give them moral support. Unfortunately, sometimes these people can be a bit of a distraction, and if you feel that it's in your client's interests not to have others there, what you might do is say to that person that you might have to call that person as a witness, and that therefore they have to remove themselves from the immediate environment and go to the witness room or go to another part of the building, go and wait in the cafe, whatever, just to get them out of the way. And of course, you're not obliged to call anyone as a witness, but you might want to, of course. But that is a way in which you can make things easier for yourself and your client if you don't have other people there who are proving to be a distraction. Let me turn now to the question of coloured pens. Now, I've spoken about this before, and I know it sounds a bit like, back in nursery school, colouring in pens and things, but I do remember conducting a proof. Well, I wasn't conducting it at counsel, and the opponent had senior counsel who went on to become a judge in the inner house, and senior counsel had a pencil case like the one you would get in a primary school, full of coloured pens and markers and highlighters, and he used different colours for different purposes. So the questions were written out in blue, shall we say, I can't remember, but say it was blue, and then the answers were written down in red, and then comments, points that he wanted to make later in submission, they were written down in another colour, green maybe, I don't know. But I thought that was a really good system, and it's one that I've tried to use as well. So in the heat of these things, you sometimes afterwards you've got your notes, and if it's all in the one colour of pen, you're never quite sure sometimes whether something you've written down is a question you've asked, the answer you got, the answer you wanted, or an observation or something of that nature. There's the coloured pens that keep it all. They'll help you keep the different categories apart, and that way you avoid a situation where you say to the sheriff that the witness said such and such, was in fact you didn't say that at all, that's what you wanted him to say. Very embarrassing if that happens. So I would recommend coloured pens, to be honest. I think it's a really good idea to do it. On the subject of taking notes, I hadn't realised what a big job it is to take notes until I was in the court of session, and I was conducting a proof in the court of session, and I had a colleague with me taking notes, and it was so much easier asking questions, particularly cross-examining, when I wasn't having to write everything down. And you can see why counsel likes to have an instructing agent there taking notes, because conducting a proof, asking questions and so on, and being alert to what's happening and being ready to object and so on, it's mentally it's quite a demanding thing to have to do. If you're having to take notes as well, that just adds to the pressure, and if you can get someone else to do that for you, then you should certainly think about getting that done. In fact, on that court of session proof, there were days where I didn't have somebody there with me, and there was quite a marked difference, I felt, between those days and the days where I did have somebody there. So I would recommend having someone there to take notes if you can afford that. If your client can afford to have that, then you should certainly do it. Next point I want to make is I always call this fraternising with the enemy, and what that basically means is that you need to be careful about how your client perceives your interaction with the opponent's solicitor. A lot of clients don't appreciate that as a solicitor you're just doing your job, and as I said earlier, sometimes it's just luck or fate who you're acting for, and it's nothing personal. And clients may resent it if you are having a laugh or having a bit of banter with someone who they see as the enemy, someone that's hostile to them, someone who's maybe been giving them a hard time in the witness box, calling them a liar or whatever. You can see why they don't want you to be too friendly with that person. So I'm not saying be unfriendly to the solicitor on the other side. I'm not saying that at all. I'm just saying just be careful about how your interaction is perceived by the client, and if you are going to have a joke or a laugh with the solicitor on the other side, try and do that when you're in the agent's room, or at least not in the courtroom where the client is, because they may not appreciate that at all. Another point I would make is that during the evidence, during the point where the evidence is being given, sometimes people will say things that are significant, either in a good way or a bad way. And I've seen plenty of times solicitors on the other side writing things down in a very emphatic sort of way. So they'll write it down and they'll underline it, or they'll put exclamation marks after it, or they'll do it in block capitals. And sometimes, of course, in courtrooms, courtrooms can be quite small. I mean, the ones that they used to have in Hamilton, for example, the ones in the Beckford Street building, they were tiny wee courts, and you couldn't help but see what your opponent was writing down. You didn't really need to be skilled at reading upside down to see what they were writing, and you would quite often see what they were taking down as important and what they thought was significant and so on. and you would notice it, and that was quite often something that they probably didn't want you to do. So try not to give away too much about how you perceive the evidence coming out. If you write something down that's significant, even if you look horrified or elated or dismayed or anything like that, you're giving your opponent notice of something that he should maybe try and react to. If somebody says something significant, usually your best form of reaction to that is to try and not be seen to react at all. I hope I'm explaining that all right. Just try and be kind of impassive. Don't look as if you're reacting. Try and just look poker faced and carry on. You don't necessarily want to draw to your opponent's attention something that's significant at that point. It's alright afterwards, once the proof is finished, of course, but whilst the proof is still ongoing, sometimes if you draw attention to a matter, then your opponent can address it. They can try and put it right. They can try and correct it by asking further questions in the proof. Once the proof's over, they can't do that. Excuse me. Right. Yeah, I mean, you need to be careful as well about allowing, during cross-examination, you don't want the person you're cross-examining to be able to put right something damaging that you're going to raise after the proof is finished. For example, I had a divorce proof where I was acting for the wife, and the opponent claimed in his pleadings that he couldn't work because he had back problems. Now, he didn't say in his evidence in chief that he'd seen a doctor. He hadn't lodged any medical evidence. So when it came to me cross-examining him, I could have pointed this out, and I could have said to him, have you ever done anything about your back? Have you been to see anyone? However, if I'd done that, that would have alerted him, because he wasn't an idiot by any means. It would have alerted him to the fact that he hadn't said anything about going to see a doctor when he was examined in chief. And he could have just lied during cross-examination and said that he had gone to see a doctor, and I couldn't have refuted that. So I didn't want to give him that opportunity, so I never asked him about it at all. And then after the proof was finished, in submissions, I said to the sheriff, there was no evidence that the husband had seen a doctor, there was no written evidence that he'd ever seen anyone, and the sheriff, of course, then made the appropriate finding in fact, or didn't make any finding in fact. So there was no finding in fact that he had any back problems or had ever seen a doctor about it. But the point I'm making there is, if I'd raised that during the proof, it would have alerted the guy to the problem, and it would have given him the opportunity to put it right. Whereas by not mentioning it, he didn't know about it, he had no notice of it, and he didn't have the opportunity to do anything about it. Pace of questioning. Right. When you're questioning witnesses, try and go slowly. I say that because I've observed hundreds of proofs, and in my opinion, most solicitors ask questions too quickly, and it's understandable. There are different reasons why that happens. If you're nervous, and we all get nervous doing proofs. If you're nervous, you can there's a tendency for you to go too quickly. If you've written down the questions you're going to ask, it's easy to go through them too quickly as well. Also, if you're trying to catch a witness out, you're trying to pin him down, you're trying to set a trap, catch him, lying out or whatever. It's too easy just to bombard the witness with questions and make sure he doesn't have the time to to invent an answer. But the problem with that is you need to remember that the sheriff doesn't know as much as you do about the case, hasn't seen your questions, doesn't necessarily know where you're going with it, and they can sometimes lose track of where it's all leading, and that is not what you want. You don't want the sheriff to lose the place. You don't want the sheriff to get annoyed about it, and you certainly don't want the sheriff ordering the extension of the shorthand notes. Sometimes cross-examining somebody slowly actually helps your case, because it can emphasise, particularly if the witness that you're dealing with is a chancer, it'll actually emphasise that they're not answering reliably or credibly, because you're giving them a full opportunity to give their account, and if they can't actually do that, then they can't use the excuse that they didn't have time to give their answer thoughtfully. Next point I would make is ask questions that are intelligible to the witness. For example, the one that I always notice this. The one that I notice is to do with measurements, distances, measurements, that kind of thing. So make sure beforehand that your witness understands units of measurement. In my experience, and I've done hundreds of road traffic cases, in my experience, most people are absolutely hopeless at judging things like speeds, distances, and so on. So you'll ask a question like, how many car lengths were you from the junction when you saw the other vehicle emerge from the side street or whatever? And most people don't have a clue how to answer that question, so they'll give an answer that's usually just a guess, or they'll say they don't know, or they can't estimate it or whatever, but nearly always the evidence is completely unreliable. I mean, I'm not saying incredible, I'm sure they're doing their best to answer the question, but it's really difficult to get accurate and reliable information from witnesses in road traffic cases when it comes to distances. And quite often you end up having to try and formulate questions as the answers come out, and you can end up asking all kinds of questions that you probably couldn't even answer yourself. I mean, I've been a driver for 40 years, and I would struggle if I was asked to estimate the distance between a moving vehicle and a set of traffic lights at any given point. And you can ask questions, you'll get an answer, like you could get an answer that might be 10 car lengths, 100 feet, 100 metres, all kinds of permutations. It doesn't help as well that we still use the imperial system of measurement, when most people nowadays don't really understand yards, feet, miles per hour. They tend to be more familiar with the metric system, but we don't use the metric system on the roads. I even had a case once in Hamilton Sheriff Court, all to do with a collision on a roundabout, and it turned out that the witness was talking about a different roundabout from the actual roundabout where the accident happened. Anyway, the best way, in my opinion, to deal with road traffic cases is to use lots and lots of photographs, particularly Google Maps type aerial photographs, that kind of thing. And that way it helps a witness, helps the court to try and envisage what happened. And you're not then left with, all these sort of questions like the time it takes a car travelling at 30 miles an hour to collide with another vehicle doing 5 miles an hour in the opposite direction 15 metres away. Who on earth can answer these sorts of questions? So